Thank you, Mr. Chairman. Let me ask Ms. Eiffel, I guess, the issue about felon voting rights. Tennessee has a provision in its law that says that if you're not current in your child support, you can't get your right to vote back. As a felon, you can be back on your child support if you're not a felon and you can vote, but if you're a felon, you can't get your rights back. Do you know of any other state that has such an impediment to voting?
Well, I do know that some states that have sought to restore the right to vote to formerly incarcerated persons have made that right contingent on the full completion of the sentence,
right,
which can also mean the payment of fines or fees, can also mean probation, and so it's not predicated simply on having been released from prison, but it carries with it all of the additional things that might go along with a sentence.
Yes, Tennessee has that, but they also have child support.
I have not heard that imposed in other jurisdictions.
It was, anybody on the panel heard of child support? Yeah. That was put in, I sponsored the bill in the Senate to restore voting rights, and that was put in by a House member, and I think it was done for a pernicious basis. It's hard to keep current on your child support if you're in prison for a long time anyway, but that's still part of the law. Where are the states, Ms. Eiffel, that have, most of the states that have prohibitions on people having the opportunity to vote if they've committed a felony?
Well, they have been all over the country, but certainly there was a concentration in the South. As you may know, some of the history of these laws emanated at the turn of the 19th century, I guess the turn of the 20th century. After Southern states received back their power, they passed new constitutions. This is after the Civil War and after Reconstruction, around 1900. And we saw the expansion of ex-felon voting restrictions in state constitutions during that period when there was a very robust effort to try and disenfranchise, at that point, newly freed slaves who'd been free for several decades.
I was a history major, and so it astonishes me. It's amazing. You know, in Memphis, we had a statue of General Nathan Bedford Forrest, and it was recently taken down. And it was put up right at the turn of the 19th and 20th century. It's amazing how that coincided with the felon voting issue. Just things happen, amazing. Of the states that were in the pre-clearance, 7 of the 9 were southern states, is that correct?
That's correct.
There were a lot of smaller jurisdictions in New York and Michigan and in some other areas of the country. What percentage of the country that was in pre-clearance that was justified were in the old Confederacy? By population, do you guess?
Most of them, certainly most of them.
Yeah.
Most of the jurisdictions that came in that were in the North came in the 1970s under the language provisions of the amended Voting Rights Act, and that's when 3 boroughs of New York, for example, became part of the pre-clearance regime.
And the state of North Carolina wasn't there. Ms. Gupta, you mentioned that North Carolina and one other state, was it Texas, that jumped right into action and put in some old bans after that?
That's correct.
So North Carolina, which was not one of those 7, has kind of moved up and joined their, is that correct? Is North Carolina one of the worst states now?
There were jurisdictions in North Carolina that were covered by the pre-clearance regime, but there are certainly, I will say, and this is exactly why we welcome the opportunity to develop a full record about contemporary discrimination. Unfortunately, we have seen an expansion, kind of a metastasization of voter suppression now around the country. It used to be that you saw these kinds of overt acts in the South, and unfortunately, the disease of voter suppression really has metastasized to a lot wider jurisdictions around the country. And we saw in North Carolina, the state actually enacted a statewide law that was considered the most restrictive in the country after Shelby County.
How would you recommend to us to find the jurisdictions that are the most heinous in terms of finding ways to discriminate?
Well, we welcome the opportunity to develop a record, to give testimony. A lot of our organizations in the Leadership Conference Coalition, including the NAACP Legal Defense Fund, MALDEF, Lawyers Committee, Brennan Center, we have been collecting this evidence as best we can, documenting small and big changes that have prevented people of color from accessing the polls when laws were changed or changes were made, both small changes and big. And it is imperative that we collect this evidence, put it before you, so that you can restore the Voting Rights Act in concordance with the United States Supreme Court's opinion in Shelby, and create a formula that will allow the Justice Department now to ensure, before people lose the right to vote, before elections take place, that people are not unfairly and unlawfully prevented from participating in our democracy.
My time's about out, but if I can ask the indulgence, our Constitution's a great document, I concur, but you have to remember that the original sin of this country was slavery, and the original document was drafted with slavery in mind. That's why African Americans were considered three-fifths, not three-fifths for voting rights, not three-fifths, but three-fifths for purposes of southern states having representation in Congress and in the Electoral College to maintain the system of slavery that was in this country. It was part of our charter, and except for the Civil War and the 13th, 14th, and 15th Amendments, we'd still be there. And we're still fighting it today. And it took John Lewis in 1960, the 60s to go to Selma and to march, and Dr. King to march, and for us to get a Voting Rights Act. We're way behind, and we need to catch up and remove ourselves from that original sin. I yield back the balance of my time.